Next case up for argument is Kimberly versus Marcel Noel. Case number 18CA0080-M. Counsel for both parties are present, so each will have 15 minutes to present their arguments. The appellant, Mr. Donor, of course, may reserve up to 5 minutes for rebuttal. If you wish to reserve time, let me know and I'll keep track of it here for you and let you know as you're getting close. We've read the briefs, we're prepared to proceed. The only other thing I'd say is if there are children involved in the case, we use initials only, and we do record, so keep your voice up at the podium. Other than that, we'll hear from you.
Thank you. Please report, I am John Donor, and I represent Marcel Noel. He is the trial defendant and the appellant in this matter. I would like to reserve 5 minutes for rebuttal.
I'll let you know when you get close.
Thank you, Ed. The first thing I will bring up is I'm going to tie it together with two things, and one is a case that was cited both by the appellee and by the trial court, and that is the case of Evans versus Evans, where this court recognized that it's been held that an indefinite award of spousal support should be modifiable, and a trial court abuses its discretion by failing to reserve jurisdiction to do so. It relies on the Norrie case and the Robiner case. I've cited the Robiner case, and I also cited it to the trial magistrate and to the trial court on objections that says essentially the same thing, that it is an abuse of discretion, and our position was it made that part of the agreement unenforceable.
But again, that was a decree, right?
Yes.
And this is a dissolution agreement they have.
It is, Your Honor, and I will point the court to the recent case in January, I also cited Smith versus Smith, where the decree, and it was a dissolution also, is grossly inequitable and was clearly designed to take advantage of the fact that husband was unrepresented. Here, husband was unrepresented, and the brief that I have filed on behalf of Mr. Noel provides a litany of things that he was locked into paying, some modifiable and some not modifiable. I would maintain that spousal support is modifiable, and the court made a mistake in not finding that provision of the decree of dissolution was unenforceable. In the hearing before the magistrate, the issue of the tax exemption came up. At the time the appellant trial defendant, Mr. Noel, filed his multi-part motion, his ex-wife, Ms. Lucas, had not filed tax returns at all. It was unclear at the trial whether she had filed tax returns. She had an affidavit that stated she had no income. She had spousal support as income that she was receiving. She had presented a financial affidavit showing a moderate amount of expenses that she is paying for this child. On the other hand, Mr. Noel provided his tax returns. It showed his rate of tax being paid. It showed the higher tax rate that he was being paid. It showed the expenses that he was paying, and there was no real allegation that he was behind in any of these payments, tuition payments and extracurricular payments and child support and spousal support he had been current on. There was more than sufficient evidence in the record for the court to be able to determine that the best interest of the child would be to allow dad to continue to be able to pay these expenses. Father also testified at trial, I have to borrow money because of my reduction in income. I have to borrow money for this for me to be able to pay these things. The court did adjust the child support, the trial court did adjust it slightly, but it did not take into account the private education costs that the father was paying. And in fact, I'll come come back to this later, but I don't think the trial court adequately addressed or completely addressed that assignment of error in the August 2018 judgment entry from the trial judge. But the child support and private education, she said the trial judge said she would not put together and consider.
That was because the child was not emancipated yet, I believe.
Yes.
And that's what the decree, or the separation decree.
That's correct. In less than a month ago, this court decided the case, remanded it because the trial court did not put together the private education of a child along with the child support calculation and remanded it for further action. That case is Elliott Thomas versus Lewis. It was decided September 25th. The appellate case number, it's a Summit County case 29164, 2019 Ohio 3870.
And did you file a motion to supplement?
No, Your Honor.
You realize that's what you're supposed to do.
I do not.
It's in our local rules.
The without taking into account the additional expenses of the father, child expenses and other expenses, we argued that it was inappropriate and incorrect for the trial court and error for the trial court not to further modify the child support obligation. With that, I will save the rest of my time for rebuttal.
And you will have a full 5 minutes, Senator.
Thank you.
Council will have a full 15 minutes.
May it please the court, I'm Todd Marcel. I'm here on behalf of the appellee, Kimberly Lucas, in this case. The first thing I'd like to ask this court to do in deciding this appeal is to go ahead and trace through from the post-decree motion to the objections and the supplements filed to the appellate brief to really determine what issues have been properly preserved for appeal pursuant to Rules 53 and Appellate Rules 12 and 16. I'm not going to go through, it's a bit laborious if you look in the brief how we've explained this, but for instance, if you look at the post-decree motion, a couple of the issues that aren't even raised in there but that are touched upon in the briefing are like the life insurance policies that have to be maintained to support the support obligations, and also the extracurricular activity expenses for the minor child in this case. Those aren't even addressed in the post-decree motion that was brought in the first place. When you look at the objections in the supplement, you'll see that they are very unspecific and general. They generally state that there was error without saying why there was error. This court in Stanley versus Stanley determined that there has to be specificity tied to the objections. For the most part, that wasn't done here. Then Appellate Rule 12 and 16 require that each of the assignments of error be separately briefed and sufficiently argued. I think when you go through and look at all of the, if you look from the beginning to the end, you'll see that very few issues were preserved and argued for appeal. With that, I'd like to go on and actually address the issues as they appear in the brief to the extent that I can. The first real issue, and I think maybe it's the linchpin issue, that at least as it appears in the brief is on pages 6 through 7 of Mr. Noel's brief. He makes an argument that I believe is fairly novel under Civil Rule 58B. States that because there is no notation on the docket of service of the decree of dissolution, that makes the decree of dissolution a non-final and appealable order. He then goes on to extrapolate from that because there was no non-final appealable order, that the court was free to basically treat these motions to modify as if they were pre-decree motions made under Rule 75, and not subject to any of the statutory requirements for modification that would normally apply. Where that argument kind of falls apart is in its initial premise. This court in Witherspoon versus Witherspoon, which is a Lorraine case from 2017, holds that service under Rule 58B doesn't affect the validity or finality of a judgment, only the time to file a notice of appeal. Mr. Lucas has not appealed the decree of dissolution in this case, although he raises collaterally several challenges to that decree. It was not named in the notice of appeal as the judgment being appealed in this case. There's general law that states that you can't collaterally attack a decree through post decree motions to modify. The cases are cited in my brief that state that. And why this is important is that if he were actually appealing the decree at this point, what he would have to bring to this court is a separation agreement that he signed, a decree of dissolution that Mr. Noel acknowledged, and a transcript of those proceedings where the court specifically questioned him on his intent with respect to whether this was his voluntary and knowing agreement, whether he knew he was going to waive trial on these issues by doing that, and all the other protections that a court does when it enters a decree of dissolution with a separation agreement, where the parties have contractually determined what's going to happen with respect to their divorce instead of making the court make those determinations. For that reason, I think that the major premise really falls apart and can't be relied upon. Interestingly, if you look at the brief itself, most of the arguments that are made are based on that it was inequitable for the court to issue the initial decree. If you look at the 87%, the 70%, those all track the initial decree. They don't have anything to do with what actually is the reality after the court actually modified child support downward and looked at it. So there was a statement before that the court didn't look at any of the issues of what the father paid. If you look at the magistrate's decision, the magistrate actually went through all of the deviation factors in determining that there should be a slight upward deviation. Didn't order a downward deviation as father had requested, but went through all of the requirements under the rule subpart 22 and 23, including the in-kind contributions of the father in paying school expenses and his other court-ordered support. So that statement isn't entirely true. The magistrate did go through all of those in making that determination, and the court upheld the magistrate's decision in that respect.
Counsel, is there any disagreement between the parties as to his actual income?
No, I don't believe there is.
And the amount that he pays each year?
There may have been disagreement that was stated. I was not trial counsel at that case. I think there was some issues about whether that was voluntary or involuntary, but I don't think there was any evidence of record that would state that his income is anything but what the court ultimately determined it was. So I'm going to go on to the next argument that's made is basically, and what's addressed here is the case under Smith versus Smith. And one of the big reasons why that case is distinguishable, Smith versus Smith was a 60B case. It wasn't a case on a motion to modify in this case. The other issue is that Smith versus Smith, the court acknowledged and I think went out of its way to say that that was an anomalous case. It wasn't just looking, I think, at the inequity or apparent inequity between what the father agreed to and what the court would have ordered. What it really seemed to sink its teeth and it found to be a violation of public policy was language in the decree which promoted potentially Medicaid fraud. And the court, I don't think, meant to open Smith up as a vehicle for parties who are not satisfied with what they agreed to in a separation agreement to come back later and say that that isn't equitable. I think that's a misuse of the case. There are also some big distinctions factually between that case and this case. One, in that case, I think the only real similarities in that case and this case are, in both cases, the father was unrepresented at the time they entered into the separation agreement. And the other issue is that the father agreed to pay private tuition in both cases. The big difference is the court noted, I think in Smith, that it was a very short marriage, a 5-year marriage. This one was a 16-year marriage. And it also noted that there was nothing on the record showing that the mother in that case was unable to earn an income. There is a lot of evidence in this case that demonstrates that the mother in this case hasn't worked since 2006 because she suffers from debilitating medical conditions. And that is actually acknowledged in the separation agreement itself.
Counsel, I would agree with you that that was a 60B and Medicare fraud was a huge issue. But I think the court also looked at the fact that the inequity of it, that he was unrepresented due to the fact that almost all of his income was going to support mom and the child or the children. And that, it seems like that's the same thing here.
Well, even if you were to say that, Your Honor, I believe that it came up in a different context of the 60B in which you can attack those kind of issues. If the father wanted to do that, at this point he's out of time to bring a 60B because it's over 1 year. He also did not challenge the decree itself. He's trying to use this motion to modify as a Trojan horse to attack collaterally the original decree, which I think is improper and has been shown to be improper by cases such as Allstate versus Witta and in re marriage of Henson, which are cited in my brief. So to the extent that the court did look at both those factors, I think that looking at them in this context with respect to a motion to modify is improper. The idea of a motion to modify, there are statutory factors that require changes, and whereas like cases like Abramson, which is also Abramovich, I think is the actual name of the case, and Haas, which are state that where parties agree in a separation agreement to a state of events that they're entitled to have those expectations that they've made in contract and to rely on them reasonably. When there's something extraordinary that can be shown outside of undue influence, any of those issues, then I would say that 60B is the proper vehicle to address that on a motion to modify. So I'd like to go on at this point to address the argument on page 7 of Robinson and Evans that we heard earlier. And I think those are, as well, are easily distinguishable in that those cases all involved divorce decrees and orders by the trial court itself of spousal support. In that case, the courts determined in Robinson, which is an 8th District Court of Appeals, that determined that it was an abuse of discretion not to reserve jurisdiction to reconsider that. In Evans versus Evans, they acknowledged that case in dicta. I don't think they made that case, but the big distinction between those cases that has also been acknowledged and determined by other cases, including one which I cited, the name, I think it's Lawson versus Garrison out of the 6th District, is that those cases involved an award by the court as opposed to this case, which involves a separation agreement and a decree. And the big difference, if you look at that, is the statutory language of 3105-18E2 and F2. And in those cases, they talk about where the parties agreed to support under a separation agreement that is incorporated into a decree of dissolution, that you have to have jurisdiction and agreement by the parties to modification. To apply Robinson and Evans to this case would read out entirely Ohio Revised Code 3105-18E2 and F2 out of the statute. It can't be what it means. Lawson versus Garrison discusses that and would be good precedent, have not precedential value, but obviously some persuasive value to this court, and I think gets it right. The final argument as to the award of the tax dependency exemption, and the trial court isn't required to state its reason on the record for awarding that exemption. The IRS creates a presumption in favor of awarding it to the residential parent. In this case, the residential parent is the mother. And ultimately, the burden is on the non-residential parent to produce competent, credible evidence allocating the tax dependency to him would be in the minor child's best interest. Again, Mr. Noel spends no time with the minor child. She doesn't live with him. He doesn't visit her. Stays with mom at all times. Is cared by mom exclusively. Mom's total income is based on the amount of support that she receives, which she has to support obviously a two-member family household in doing. There's no evidence on record to demonstrate that allocating that tax exemption would be I didn't mean to state that it would be in the minor child's best interest in this case, and therefore, in fact, Mr. Noel did not carry his burden. With that, unless there are any questions that anyone has of me?
No questions, so thank you for the argument.
Thank you.
Council, you'll have 5 minutes for rebuttal.
Thank you. The Witherspoon and the Blair case, it's also cited within Witherspoon and in the appellee's brief, deal with tolling time, but the position is, and it's not the pivotal position, but it is the position that there are, and I understand this is a unique argument, and this is a novel argument for this court to get, but there are defects within that were raised in the motions. In the trial court's decision, spousal support being a primary one, that perhaps that is not a final order, and the tolling would also apply to. The Stanley case and the Young case that were cited and relied upon concerning the specificity of the objections. The rule is, and what those courts cite is, there has to be specific enough legal or factual support. And there were, it can't be generalized objections. These were very specific, page after page after page of very specific objections. And the first determiner of whether or not those are sufficient is the trial court. The trial court had no problem coming out with a 19-page decision detailing each one of those, allowing argument, addressing all of those. Now to say it on appeal, well, it wasn't sufficient. The trial court found its way through that, except for, I believe it's either what the trial court characterized as 6B or 16, I can't remember right off the top of my head, that the trial court did not actually finally decide. In counsel was incorrect at one point. The 87% of income being used for expenses, not only, and the percentages used not only deal with what was initially done, but the changes that were made by the trial court in its final decision in this matter. The last thing I will mention, and I'll just touch on it because this is just one of those cases that is unusual in many aspects. But in February of this year, I'll just remind the court that after the notice of appeal had been filed, this court asked both sides to present evidence of why the August order from the trial court ruling on the objections was a final appealable order. The appellant responded, the appellee did not. It was requested that specific documents be provided to the court. Those were provided then on February 1st of this year. This court stated in the magistrate's order, as with all appeals, the issue of jurisdiction may be revisited during the final disposition of the appeal. One time at a conference, Judge Eve Belfance was asked about what do you do when you don't think you have a final appealable order, but you aren't sure. And she suggested, well, you file your appeal and then you file a motion to dismiss. Sometimes yes, sometimes no, but the, since the court has left that issue open, I would suggest that the order from August, because it misses at least one of the objections, is not a final appealable order. It also does not incorporate all the findings and facts from the trial itself. Thank you.
Thank you both for your arguments today. The court will take the matter under advisement and issue a decision in due course. The clerk courts will mail each of you a copy of that decision on the day it's released. The opinions are also posted on the Supreme Court of Ohio's website. Both of you did an excellent job arguing. We appreciate that, and thank you.
Thank you.